I'm Doug Lichtman, and in this video, I want to think about the meaning of the word author. Normally in casual conversation, when we talk about someone and we say they're the author, we might mean a lot of things. We're kind of crediting them with having created the work, we're acknowledging what they've done. In copyright law, the word has a very specific and much more narrow meaning. In copyright law, the author is the party who gets the copyright first. That's all it means. Nothing more romantic, just that. And indeed, on the slide I kind of summarized the vocabulary a little bit. Copyright rights are originally assigned to the relevant author. Again, that's what it means. Now, once I assign the rights to the author, authors are free in copyright law to move those rights around. And as we move those rights around, the folks holding them at any time are called owners. And so copyrights can be moved by contract to different owners. And this framework is going to help us figure out a lot of things about each copyright. And let's take a look at a few of them. First, I want to show you some of the law. This is section 201, and it's where these definitions come from. 201 says that copyright in a work protected under this title vests initially in the author or authors of the work. Again, just defining it, an author is the party who gets the rights first. The provision goes on to say that the authors of a joint work, and we'll talk about this in a later video, but joint work, it's work where we have more than one author. You and I work together to create it, a joint work. And the law says the authors of a joint work are co-owners of the copyright. 201 continues in B with a really important category called work made for hire. Work made for hire, we'll read in a second, but work made for hire, an intuitive example is like I have a company and my company hires you as the employee and asks you, the employee, to create something, a book, a story, a movie, whatever. Under the right conditions, the author of that work is the employer, not the employee. And again, this is just definitional. Do an example like of Marvel Comics. If you think of someone who's working for Marvel and writing up what turned out to be a comic, I think in casual conversation, you and I would say that person is the author. We might expect them to have a byline, for example, on the front page. But in copyright law, if it's an employee working for Marvel and a couple other touchstones are satisfied, the author is not the person. The author is the employer. And again, all I mean by that is the copyright, by default, right away, goes to the company, so they can then do all the things you know they need to do. Mass produce the comic book, license the movie, whatever it's going to be. Again, 201 mentions this category. We call it work made for hire. And 201 says, in the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author for purposes of this title. Authorship, original ownership of the copyright. After that, sure, we're going to move it around. 201D, indeed, announces that we can. 201D says that the ownership of a copyright may be transferred in whole or in part by any means of conveyance, and then lists a couple. All that means is, once I've given the copyright to the author, they can move it around, they could break it into pieces, parts, give some of it to this party, sell some of it to that party. That's what licensing is. And 201 says, after we know who the author is, totally fine, move it around, transfer ownership. 202, we'll read it in a second. 202 reminds us that as we move copyright rights around, that's something different than moving physical embodiments. And just the same, moving physical embodiments is kind of something different than moving copyrights. Let's read it and then I'll unpack it a little bit with you. 202 says, ownership of a copyright or of any of the exclusive rights under a copyright is distinct from ownership of any material object in which the work is embodied. And again, just pausing there before we do the next bit, if you buy Harry Potter, you buy the book, you've bought the embodiment, but you know that you don't have any rights to the copyright. You can't make a movie, you can't do anything interesting with it. You've bought the embodiment, the book, and you have possession, ownership, control of that book, but you didn't get any copyright rights per se. Ownership of a copyright is distinct from ownership of the material. Goes on, transfer of ownership of any material object, including even the copy in which the work is first fixed, does not of itself convey rights. What's this talking about? Well, you'd have these situations where, let's say we had a boy band. This really happened to a bunch of the boy bands. Boy band, when they're getting started, they meet a producer, they record some music with this kind of sleazy producer. It's not that great. The boy band then moves on, and a year or two later, they become a much more successful entity. The question then is raised, what happens to the music that was originally recorded with my sleazy producer? The producer says, it was in my studio, I recorded it on my tape, and I have the tape. Doesn't that mean that I can do something? Maybe release an album, this is what NSYNC really sounds like. And 202 makes clear that no, just because the original producer has physical possession of the embodiment, and indeed it's the first and only copy, he recorded them singing in the studio, just because he has original full possession of that copy, no rights. He can't mass produce it, he can't perform it, can't do anything with it, because the copyright is distinct from the physical embodiment. That's what 202 is about. 204, again, staying on our theme, authors get the rights originally. Once the author has it, they can move it around by contract. Moving the physical item, that's not what we're talking about. 204 then clarifies a transfer of copyright ownership is not valid unless an instrument of conveyance, so on and so forth, is in writing and signed by the owner of the rights. 204 says, while you're welcome to move things around, you better do it in writing. And note me to you, we should do everything in writing. Anything that matters. It's really good to have writings. Writings help us make sure that we both understand what's happening at the time. Writings help us keep track of it later when maybe we don't remember what we were trying to do, maybe a disagreement comes up. We always want writings. And indeed, I always tell lawyers, try to make your writings readable. Lawyers like to write really complicated things, really long contracts, lots of jargon and so on, but that doesn't actually serve the interests of the parties. What we really want to do is write a document that at the time the parties can read, understand, and then again later when something comes up, I'd rather not have my clients need to call me or need to fight. I'd love for them to be able to read the document and say, oh, I know what we were supposed to do. You want clear written documents because that's how transactions work. And indeed, when I write contracts for clients, I often go so far as to even put in examples. Say we have a term about the economics of the deal, we'll say it as precisely and cleanly as we can, but then you really bring it to life by writing up a numbers example. Imagine we made $100 under this provision. Here's what would happen. Clean language, I always like. Written documents, I always like. I will point out to you, one reason lawyers use bad phrases is that bad phrases get litigated. An example, for instance, some lawyer long time ago wanted to write a sentence in the contract, and the point of the sentence was to say that if the other side is late, even by a millisecond, if they're late at all, contract is over. That's breach. It's really important to be perfectly on time. And instead of writing it that way, using words like even a millisecond and so on, instead of writing it that way, this lawyer wrote the phrase, time is of the essence. Terrible. It's a horrible phrase. I don't know quite what it means. But they wrote it, they then ended up litigating a case, and a judge said, after looking at all the evidence and so on, a judge said that phrase means that millisecond thing. Well, now lawyers like to use the phrase time is of the essence because there's a court case defining it. And so we get locked into this very bad language that had to be litigated because it's so bad, but now because it's been litigated, lawyers use it. All that is an aside to again say two things. You want to do things in writing even if the law didn't tell you to. And my advice to you, clean, readable writings. We're trying to inform people. We're trying to help people see issues and the like. Now, 204 says that forget Lichtman, even if Lichtman had said nothing, if you want to transfer copyright rights, it's got to be in writing. There's one then wrinkle. That phrase, a transfer of copyright, that phrase is defined in section 101. I won't show it to you in a slide. Trust me, it's defined in 101. And the definition makes clear that there's one exception. And the exception is for non-exclusive licenses. So copyright law allows me, if I want to authorize you to make t-shirts, and I'm going to let other people make t-shirts also, so it's not exclusive. In that instance, I don't have to do a writing. I should, see Lichtman, I should, but I don't have to. Everything else, Section 204 says you better do it in writing. So who cares? Why am I bothering you with all these words about authors getting the rights originally, owners getting them over time, the rules for transfer, and this distinction between transferring the copyright versus transferring the embodiment? Well, I think it does matter in a couple ways. One thing is that it matters quite a bit if it's hard to transfer ownership from certain authors to other entities. What do I mean by that? Authorship puts the rights with someone. And in most instances, we can then move it around. We'll write a document and move it. But you can imagine situations where that's not going to be easy to do. Maybe we don't have lawyers around. Maybe we don't have foresight and we didn't realize we should be doing this. Maybe there are a whole bunch of authors and it's a lot of paperwork to move all the rights and we're going to miss some. In these instances where you can't easily and reliably move the rights around, I care a lot about who the author is, because they're going to get the rights at first, and it might stay with them. Or as I say in the slide, in these situations, authorship is an important default. The rights might stay there. One reason I care about all this then is I worry the rights might stick in certain instances. There's a little bit more. Authorship also matters for two things. It matters for determining how long the copyright lasts. When you look at the law, which we will in a minute, about how long the copyright runs, the question the law asks us is, who is the author? And that helps us figure out how long it lasts. Authorship matters for duration. Authorship also matters for something called the termination right. Again, we'll dig in a minute, but at a high level, US law has this cool right where if I am the author and then I, by contract, move my rights to you, roughly 35 years later, I can call you up and say, never mind, I'm taking my rights back. And indeed, I can do this even if my original contract said, now and forever. It's called termination. Only authors have it, and indeed, only kind of human authors. If you're doing a work made for hire, this doesn't even show up. But if I'm a person and I write something and I cut a deal, I can take my rights back 35 years later. It's called termination. And for the moment, it's important because I now need to know who the author is, because I need to know, can they terminate? And if they can, who gets to terminate? And let's dig in both of those just a little bit. Duration first. 302 is the law about duration. 302 says that copyright in a work created on or after the effective date of this law subsists from its creation and, except endures for a term consisting of the life of the author plus 70 years. So again, why do I care who the author is? Well, one reason is when I know who the author is, that's how I'm going to calculate how long the copyright lasts. It's the life of that person plus 70 years. Even if they then sell their rights and they move them to a new owner, the author's life is the measuring life. In section B, we go to joint work. Remember, that's work with more than one author. For a joint work, in the case of a joint work prepared by two or more authors who did not do work made for hire, the copyright endures for a term consisting of the life of the last surviving author, plus 70 years. Again, I need to know who the author is because that defines the length of the right. One more piece, section C, for other kinds of works that are done anonymously, done under a pseudonym, and for work made for hire. And what's in common here is I don't have a person. It's anonymous, so I don't know whose life to watch. It's under a pseudonym, so I don't know whose life to watch. Or it's work made for hire. It's my example where Marvel hired someone to make the comic book, and Marvel, the company, is the author. In those cases, I don't have an obvious measuring life. And so we have law. Law says in the case of these categories, copyright endures for a term of 95 years from first publication or 120 years from creation. And so we have these rules. Right now I'm just emphasizing Authorship matters because it tells me where I fit in these rules. All right, I'll say one more thing, which is, man, that's a long time. Life plus 70, 95 years, these are really long periods of time, and I think they are, and it's a real puzzle as to why copyright law does it this way. After all, if I was giving you rights from an incentive perspective, I want to give you rights to motivate you to get up in the morning, to create this cool thing. I want to give you rights to encourage you to then share it, to disseminate it, to publicize it. If I'm giving you rights on an incentive theory, you might say, give me 10 years, 20 years, 30 years, 40 years. But it's a puzzle when I start giving you rights way into the future. You're not going to get up earlier today for a promise that 70 years from now, you'll get another dollar. Just either emotionally, like that's a really long time from now, or economically, the value of a dollar 70 years from now, it's pennies. It's not worth that much to you today. You could put pennies into the bank and they would grow into that dollar over a 70-year run. A promise of a right a long time from now, it's hard to understand how it plausibly creates incentives today. And indeed, that's the first thing I say on the slide. There's no meaningful incentive to create that can be supported by the promise of a legal right that long into the future. It seems like overkill, and costly overkill, because if the copyright lasts, it means that there is someone who's going to limit the use of that work, instead of having it flow freely however you and I might want to play with it. It's odd to see these rights last so long. Hard to align that with the classic incentive story about motivating authors. That said, we can justify it. And the way we can justify it, if we want to, is on a theory of stewardship. And here's the idea. Walt Disney Company has fought a lot to get long copyrights. Indeed, one reason the law is as it is today is Disney lobbied because they were worried that Steamboat Willie, the original Mickey Mouse cartoon, was going to fall out of copyright under the then existing rules. And they said, give me more time. Not because it will motivate Walt Disney. Walt had already passed away. Walt had already done the work. It wasn't about the incentive to create or disseminate. But Disney said, if we own Mickey Mouse, we'll take care of him. We'll be a good steward. We'll make sure that Mickey Mouse never ends up in a story where Mickey is doing drugs, or Mickey is cheating on Daisy with Goofy, or whatever might happen. If we own Mickey Mouse, we'll preserve the value of Mickey Mouse. A stewardship argument. Gershwin, the Gershwin estate rather, also came in saying, for the music, let us continue to control it. We'll make sure it's well cared for. Of course, they went ahead and then licensed it to United Airlines. So I don't know about that one. But the argument here is maybe there's no incentive to create or disseminate in terms of the initial incentives, but maybe there's something to having these things owned so they're cared for. And I don't know how much I believe that argument. Shakespeare, all of Shakespeare's works, have fallen out of the copyright system long ago, and yet they're doing just fine. We don't sit here and say, I wish someone had full control of Shakespeare. Not at all. Shakespeare's out. Lots of people still read it. People interpret it in their own movies and stories. I don't know if we need stewardship, but that's the argument. The only thing I'll add is, if that is the argument, there should be some way to free what we call orphan work. So imagine we have a work that's deep into its copyright term and no one is taking care of it. It's just sitting there, but no one's paying attention to it. The author has passed away, the kids couldn't care less. In those instances, if there's no stewardship, we really should have a way to, at least for those works, say, copyright's over. We don't have an incentive system that makes us need to leave it intact, and this isn't the Mickey Mouse story. No one's paying attention to it, free it up. And so duration as a policy matter is complicated. We do run them really long. I'm not convinced we should. Come back to our flow. We're learning about authorship and ownership. Authorship matters because it's a default. Authorship matters because it determines the length of the copyright. The last thing is authorship determines this termination right. Authors get the right to terminate. A couple quick slides just to orient you on that. First, here's the law. In the case of any work other than work made for hire, this is really important. If Where in my Marvel example, where the company hired the employee, there is no termination right. I don't have to worry that my employees can come back 35 years later and pull stuff out. This actually really matters to the dynamics of employment. If I'm Marvel today and I'm thinking between either A, hiring an employee and having their job be to make a new hero, or B, going out into the world, finding someone, freelancer or someone out there, and bringing in a hero, I want to do the in-house one. Because if I bring in the hero from outside, there might be an author who can terminate against me 35 years later. Whereas if I do it in-house, no termination right at all. That right is solid, it's mine, it won't be taken back. In the case of any work other than work made for hire, the exclusive or non-exclusive grant of a transfer or license of copyright executed by the author is subject to termination. And there's a ton of law explaining the detail of when and how in the process. But termination, I'll summarize to you, it's roughly 35 years after the contract. And so this is pretty irrelevant for most work. Most of the things that you and I enjoy right now, 35 years later, no one's going to be interested in. No one's going to watch the TV shows that we're watching. No one's going to care about Bella from Twilight. No one's going to care about the 50 or 51 Shades of Grey. Gone. Most things, this right is noise. 35 years is a long time. What we've seen, and maybe you've done the math as I'm talking, Copyright Act is a 1976 law, becomes in effect in 1978, add 35 years, and we're just recently in the turmoil of termination. And what we're seeing is the things that are terminated have largely been cartoon characters. Superman, Captain America, the X-Men, Spider-Man, Casper the Friendly Ghost, the Lone Ranger. These characters, interestingly enough, are the ones that last for 35 years and stay valuable, and we've seen a lot of termination fights about those. But for most things, this right doesn't matter at all. Very few works stay with economic or cultural value 35 years later. So I don't want to overemphasize termination, only matters sometimes. Again, not applicable to work made for hire, so Marvel doesn't have to think about this for employees. And maybe the cool legal thing, it's one of the rare legal rights where I as an author can't waive it. I can't promise you I won't terminate. No matter what I say, no matter how much I pinky swear, I have the right to terminate 35 years later. Again, this is both good and bad depending on your perspective. I think the upbeat story is if you're a starving artist and what you do is you give away, you sell your work at a really low number, you can come back 35 years later. At your moment of being a starving artist, you can't tie your own hands. You will be able to come back. And folks who like this rule, like these stories, and there are stories right on point, like the two men who created Superman. They sold Superman to DC Comics for a terribly small number. No one realized maybe that Superman would become Superman. Years later, when Christopher Reeve did the first round of really successful Superman movies, the men made a lot of noise about this. They said, we're not making money from this. We sold for a very small number. And interestingly enough, DC Comics, not because of the law, but because of either decency or public pressure, DC Comics stepped up and said, you know what, guys, we're going to give you both a salary for the rest of your lives so you continue to make money off of Superman. And they did that, and that was great, and away we went. After the two men passed away, those salaries stopped, and the kids exercised termination. The kids came in and said, all right, fine, but now our fathers had made this deal long ago. They were the authors. They'd done the work on the side and then sold the work to DC Comics. It was not work made for hire, and enough time has passed. We terminate. We want to take the rights back. And again, the upbeat version of that is it gave the kids leverage to get some of the money that, I think emotionally, fairly, properly, they probably should have access to. Their dads helped create something amazing, sold it for a low number, maybe giving them rights makes some sense. Maybe that resonates. On the downside, the problem with this flow is that knowing all this, DC Comics isn't excited to buy some Superman today. They'd much rather get their good guys, their bad guys, the characters from employees, so they don't have to deal with the kids 35 years later. You can't waive this right. We're stuck with it if you're an outside author. This is the language. I note it just because legally we almost never do this. Most of the time I give you a right and I allow you to sell it. There are only a handful of examples in the law where I give you a right and I don't let you trade it away if you want to. This is one. Termination of the grant may be effected notwithstanding any agreement to the contrary. Now, the Superman story is actually really rich. Let me give you one heartbeat more before we end our video on this particular topic. In the termination, when the kids kind of stepped up and said, DC, we want Superman back, the lawyers, as they really began to dig in, found enormous complexity. So great, the kids exercised termination, thought they were getting Superman. DC's lawyer said, hang on, wait. Remember Lex Luthor? He's not coming with you. Because while Superman was created by the dads and so maybe is vulnerable to termination, Lex was created in-house. He's staying with us. Oh, and terribly sorry, better break up with Lois. Lois is also staying with DC Comics. The dog, Crypto, stays too. And when you leave, when you terminate, remember, you're terminating the original character. That's the one you licensed. And that was the guy who was able to leap tall buildings in a single bound. The original Superman, he would run and jump. He was faster than a locomotive, but he wasn't this flying superhero that you and I know. So you terminate, but you're getting that guy, not the modern guy. So please leave the cape as you walk out. And by the way, as you're walking out with this guy who runs and jumps and has no cape and has no girl and has no adversary, as you're doing all of that, remember, termination is a US law thing. So you walk out with rights here, but not everywhere else. So if you think you're going to go make a movie, better be careful not to let that movie get shown in Canada or China or France, because you don't have rights there. It's a limited right. And the reality of the push and pull there is that pressures the kids to cut a deal with DC. They have some leverage. They can pull out to some degree awkwardly. DC has leverage, Lex, Lois, the cape, all of this. And it gives us this dynamic where what we've seen in most of the cases is termination is threatened. It leads to a conversation where some of the economics are renegotiated and the kids do okay. This happened in the Marvel universe. The artist who created Fantastic Four, many of the Avengers and so on, his kids ended up getting some money as Marvel took off and the like. What we see, it's a complicated conversation and then we renegotiate. Superman was then super interesting because while this is playing out, guess what was the main way Superman was making money in the world? It was a television show called Smallville, where Superman did not fly and he did not have a cape. It was really close to the original character. That was the property that was doing well at the time of this litigation and negotiation. All right, summary, what did we do in this video? We pointed out that authorship defines who the first owner is of a copyright. It's an important default. And we played out a little bit that authorship also tells us two things: how long the copyright lasts, and separately, who can plausibly terminate. In the next video, we'll dig into the question of who can be an author.